Good afternoon and welcome to our webinar on Illinois Public Schools Respond to Juul and the Vaping Epidemic, presented by Franzik PC and the Franz Law Group. My name is Eris Dalianis, a partner at Franzik. We are delighted to have you with us for the next 30 to 45 minutes to discuss one of the most urgent issues facing public school districts, the explosion of vaping by young people in and around schools. With me this morning is my partner, Michael Hernandez, along with William Scheinoff from the Franz Law Group, the attorney and firm leading the litigation effort for public schools across the country against Juul and its distribution, marketing, and manufacturing partners. You've provided us with good questions during the registration process that we plan to address during the course of the webinar, and you can send us additional questions during the webinar through the Q&A function that we will endeavor to answer as time permits. Our goal for the next while is to discuss what is Juul and the vaping epidemic, why are school districts across the country suing Juul, give you a little overview of the nature and status of the litigation, introduce you to the presiding judge, Judge William Orrick from California, talk about the objectives of the litigation, and then answer the question, how can my school district get involved? With that, why don't we get started? So William, help us answer the question, what is Juul?
Thank you. Juul is one of the most popular e-cigarette brands in the US today. It started off at Stanford University of two gentlemen who started this as their doctoral thesis project, and within a 5-year time span became a $32 billion company. Juul, it was very innovative. It was focused on being a tech product, and what they realized with other e-cigarettes and what they know needed to be done was that people were not getting the nicotine that they were used to getting from cigarettes. And so what they did is they created a product that had extremely high nicotine content on it. And also what they did is they invented something that allowed the consumer to be able to inhale a significant amount of the product without having any physical effect. And that's the nicotine salts that's in the product. So a consumer can go and sit down in a 30-minute time span and inhale an entire pod. And what we've found is that one of these pods is the equivalent of 2 packs of cigarettes of nicotine. And as we're all very well aware, no one can go and smoke 2 packs of cigarettes. In this issue of high nicotine content and who that consumer ended up being of the product is the reason why we've seen the youth vaping epidemic today. And one of the main components of why the youth have been involved in their product is how they marketed their product. They marketed their product to intentionally focus on children. They took the concept based on what Big Tobacco did years ago, which is the idea that if we go and market the product to young people and we hook them to our product, addict them, we can create a customer for life. And so what you would see is, as you'll see in these pictures, extremely bright colors. They created flavors that were kid-friendly. And they use different markets to go and attract kids. So social media, television, online, where they knew that there would be kids that would be the focus of this marketing. And the issue also was the fact of what did they talk about when they provided information on the product. What you always saw at the beginning was it's safe. It's the safer alternative to cigarettes. It's safe, it's safe, it's safe. What you never saw was the fact that this product contains nicotine, period, or how harmful nicotine is, or how high the content of nicotine is. And so if you would go and talk to your students today and ask them, what do you believe is in a Juul? Not over 90% of them is going to tell you this is flavored vapor water. They don't understand that of what's really in it, the chemicals that are in it, the fact that the reason they're doing it so much isn't because they think it's cool. The fact is they're addicted. And so that's really what has gotten us to where we are today with Juul. And here's another example of the type of advertising they did. They did launch parties, And what you'll always notice in all their advertising is extremely young people and people that look like the main consumer, teenagers, young adults.
So William, why don't you tell us why school districts are suing Juul?
Yes. So the reason that we started this process, I myself am a former education law attorney. I represented school districts throughout Southern California for 10 years. And what I saw was that vaping was becoming a huge problem across the board with all my clients, and that it wasn't a dependence on the community. It wasn't a socioeconomic issue, but what it was becoming a disruption to the learning environment. And what it was also becoming was costing the districts a lot of money with staff time and taking steps to either deal with suspensions or expulsions or do restorative justice with children. And so when I looked into this, I decided that we could focus on seeing if there was an ability to hold these companies accountable, get funds for school districts to be able to compensate them for any harm that they've suffered to date, but also get them the funds necessary to deal with this issue in the future, which we will discuss later on to discuss specifically what we're seeking for our clients.
Mike, you want to talk about some of the legal theories of liability? You're muted, Mike.
Sorry. Sure. So, we go from state to state. William has to determine what's the appropriate liability theories to present. And in Illinois, there are multiple theories that we have used in the filing for our client school districts. And again, a part of those participating today are people who are involved in the litigation or people who are interested in the litigation. And so the theories that we have presented in the Illinois cases are public nuisance, civil RICO theory, as well as negligence and gross negligence. And William's going to talk about an effort by Juul to have the RICO theory dismissed, but that was unsuccessful. We'll talk a little bit more about that as we move on. And then let me talk a little about the vehicle for this litigation. This is not a class action, right? There have been some attorneys that have presented it as a class action, and we've advised our clients against participating in that because it's too difficult to, we believe, establish a class for school districts. I have in the past been involved in mass litigation involving asbestos. And in the past, there was no really vehicle to organize these types of national litigation actions. But that has changed over the last decade with the multi-district litigation approach in the federal courts for mass action cases. And I'm going to ask William to specifically tell us how it's being implemented in this case.
Yes. So this case is what we call a mass action. So what that means is that each school district, charter school, private school that gets involved in this case has their own claim on file, has their own lawsuit on file. What ends up happening is when there are so many plaintiffs involved against these defendants, and so just to make sure you understand who these defendants are, like I said, one of them is Juul Labs, the major vaping manufacturer in this country. And the other defendant is Altria, which many of you may know is Philip Morris or Marlboro. So what's happening is we are filing these cases individually in federal court. And because to be able to do it for judicial efficiency and to make sure that we're not litigating these cases for a significant period of time, what the federal court system does is they go and consolidate it into one courtroom. In this case, they've consolidated it into the courtroom in the Northern District of California in San Francisco, which was formerly the headquarters of Juul. What also happens in these types of multi-district litigation is we go and we all work together, we do our discovery together. But what happens is that for the discovery process, what they do is they select a number of plaintiffs to be a representative for a trial. And so in this case, there has been 6 school districts that have been selected. They're varied in size. Some are small, some are medium, some are large. And they're from throughout the country: Florida, New York, California, Rhode Island. And so what's going to happen is, if there is no resolution, in March of 2022, we will have a trial with those specific plaintiffs. This will then give the opportunity for the defendants to understand how these legal theories of liability will work in front of a jury, and also understand what a jury will award if they were to keep going to trial on these cases. And so that's the multi-district litigation process. Unlike a class action where you would have 2 or more representatives for an entire class that represents everyone, and that at the end of the day, if there's a resolution, it is split between everyone evenly. But with this mass action, another important factor is the fact that now your district, charter school, private school now has a seat at the table. And what that means is that there's going to need to be an individualized resolution, which is important for us because we believe that it's going to take a significant amount of funds to be able to provide what we believe is necessary for you to be able to combat this in the future. And a class action would not provide us with that. And so that it's going to be up to you and your board to make that decision of whether you want to resolve your case and for what that number would be. And that's the true importance of a mass action.
Let me talk a little about what's happening in Illinois, and then ask William a little about our map here and what's happening nationally, because the cases are active. There's no individual discovery, but there are motions, there are Q&As that are being answered by districts. So the litigation moves forward in that respect. We represent 25 school districts in Illinois that have either filed or are on the verge of filing complaints in the multi-district courtroom. In California, there was a recent, what we'll call a victory for the school districts in the attempt by the Juul defendants to have the civil RICO case, that part of the case, that count dismissed, which is an important count. So, William, if you could talk a little about the other states involved and about the actions such as the motion to dismiss, which was denied.
Yeah. So currently my firm represents a little over 465 school districts and charter schools in 37 states in the country. I've been working on this case for close to 2 years now. And due to COVID, there was a slowdown in the amount of school districts or charter schools getting involved. But now we've seen a significant amount more of school districts and charter schools and private schools that want to get involved, and they're getting involved this summer. In regards to the motions to dismiss, as in every litigation, defendants will always make an attempt to try to dismiss a case prior to getting to a jury. In this case, we've gone through 2 motions to dismiss against our cases. The first was at the end of last year. They claimed that schools had no right to bring these cases. What they said is the legal term is we didn't have standing. There's been no harm. And what I've never seen before, the judge that's in charge of this case came down with a 150-page opinion saying that we had all the right to bring these cases. That schools and the children were foreseeable harm based on what the conduct of these defendants of what they were doing. And that schools have all the right to bring these cases to go and hold them accountable to pay for the harm they've suffered and will continue to suffer. And that taxpayers should not be held to pay for this issue moving forward, that these corporations should be responsible for fixing this problem in the future. But they did grant one cause of action to dismiss, that they claimed we could not go and bring a case of RICO. RICO, as many know of it as the Racketeering, Influencing, Corrupt Organization Act, was a criminal charge that was brought against the mafia years ago. But what has happened is they've also created a civil version of that claim for companies that go and do illegal conduct for purposes of financial gain. And so you would see that in the tobacco litigation. You saw that claim being made in the opioid litigation, which we're hearing all about now. And we were making the same claims here. But what we asked from the judge when he granted their motion to dismiss on that one cause of action was to give us the right, based on the discovery we were doing at that time, to amend our complaint, provide more information to support our claim, which the judge did. we amended our complaint, and they brought again another motion to dismiss. However, this time the judge denied their motion to dismiss based on the further information we provided. And this RICO claim is against specifically the owners of Juul and Altria, based on the conduct that we've learned. RICO is significant because what occurs in a court is that if a jury finds in favor of us on a claim of RICO, the judge automatically awards what's called treble damages. So he triples the amount the jury awards in addition to attorney's fees. In addition to this case, we're also, as Mike went over the causes of action, we're also requesting punitive damages. And that's important too, because we're also looking to make sure that we stop this conduct. And one way that our legal system stops conduct of corporations like this is by punishing them financially. And that's what we're looking to do.
You know, before we talk about the judge, I just want to add one point. There's longstanding precedent for school districts to obtain damages from these types of companies. This is not a PI case, but rather, for example, in the asbestos cases, there were property damage cases because asbestos had to be removed from many school districts. This we're starting to reach into the programming and the damages caused by that, or the anti-type of programming and addiction programming that needs to be put on. So there's clear precedent for these types of cases and relief.
So let's talk about the judge a little bit. The judge handling these cases, like William said, they're for school districts around the country, but they're all filed in and consolidated in the Northern District of California. The courthouse is in San Francisco. So Judge William Orrick III is the presiding judge. He was appointed by by President Obama in 2013. He was a veteran lawyer, practiced for 25 years prior to his appointment, served in the U.S. Department of Justice in the Civil Division. His father happened to be a federal judge. He's a native Californian, and he's a very experienced guy. So he's presiding over these cases. He's been making the rulings that William's talking about. And interestingly, when he was appointed in 2013, he was appointed to take the place of a judge whose name was Charles Breyer. Charles Breyer is the brother of Stephen Breyer, who is the U.S. Supreme Court Justice. So it's a bit of a small world in terms of some of the personalities here, but Judge Orrick took the courtroom of Judge Breyer, the brother of Justice Stephen Breyer. So let's talk about, William, maybe a little bit on this North Carolina Juul litigation that's been in the headlines recently with the big settlement.
Yes. So North Carolina was going to be the first public entity case to go to trial. This case was brought by the North Carolina Attorney General on behalf of the state. But what's important was the fact that he was making the same claims under the same legal theories as us. So this was going to give us the opportunity to understand how a conservative jury in North Carolina would find on behalf of the claims that we were making, because it's the same exact case, but it's being handled on the statewide level. But what's also important was the fact that his focus in his case was providing support for education for the community. His damages were different than ours, but again, the importance was the fact of how did our legal theory work in the fact of what would a jury find, and give also the defense an opportunity to see, here's the first trial, what's going to happen. So this was supposed to start, like I said, 2 weeks ago. On the first day of trial, Juul Labs, before they even got to get in the courtroom that day, they announced a settlement for $40 million. This is significant. This shows the fact that this company understands now that there is a harm, that this is a very serious case, and that the claims of public entities are legitimate and real. And now this has also caused an uptick in public entities wanting to get involved, because there were some that were on the fence of whether to join, but now that they see through the process of this litigation that there is a light at the end of the tunnel, that this case is doing that. But also what was important in this case was which is also the focus of our cases. Not only did this bring $40 million to the state of North Carolina, but he also got the injunctive relief that we're also requesting. And so what injunctive relief is a order by the court to seize conduct by defendants. And so what they agreed to in this case is what we're looking forward to as well. So what ended up happening was they're limiting the amount of sales of their product in the state. They're stopping their marketing practices, so they're not going to have anyone under the age of 35 be on any of their advertisements. They're going to go and stop the sale of flavor pots. They're limiting the flavors that they're going to be selling in the state. And that's exactly what we're looking for too, because not only, which I'll go over now, not only are we looking to get the funds necessary for our districts, but we're also looking for change. And in this litigation, and as we saw in North Carolina, we're getting change in this case. So this brings me to the next point of what is the objectives for the litigation for our school district, charter school, and private school clients. So under a public nuisance theory, we have a right to claim past financial harm, but also future harm. So when I talk about past financial harm, what we're focused on is, has your school spent money on vape detectors? If so, get you reimbursed for that. Has your school spent money on putting on educational programs regarding the harms of vaping? Get you reimbursed for that. One thing that I know across the board that I've seen with all of our clients is the inordinate amount of time spent dealing with vaping on campus, whether that be administrative time, staff time, paying for lawyers to deal with vaping policies, or even handling suspensions or expulsions. We go and we will be asking you certain questions. We have an economist that will go and put a report together for us to show us how much financial harm you've suffered to date. But then we go and we look forward. And a big part of what's important in this case is we're looking to abate this epidemic. What that means is we're looking to remedy the issue. And so what our experts have told us is we need to focus on deterrence, support, and education. And one way we can deter vaping on campus is by getting you the funds to install these vape detectors. Because right now, smoke detectors do not work to catch kids that are vaping, and these vape detectors will work. The issue, though, is vape detectors are extremely expensive. They can cost anywhere between $3,000 to $5,000 a room, whether that be a bathroom and a classroom. And as we're all well aware, this is a product that was created so you can't be caught doing it. It doesn't leave a smell. It disappears within a matter of seconds. And so kids are doing it even when a teacher's back is turned in a classroom because they can't be caught. So with a vape detector, it will set it off. They will be caught. And what we've seen with schools that have done it, their numbers have dropped significantly because kids will now know they're going to get caught for this. So what we're looking at is we'll be working with you to figure out where you would want to put these. Do you want to put them in all your bathrooms? Do you want to put them in your classrooms as well? And then we'll determine how much money that would cost to do that. And so that will be one item of damages we're going to be seeking. Another thing we're looking at is the fact that for deterrence is funding for staff and supervision, putting more eyes on your campus so kids can know that it's being looked out for. They can't hide it anymore. But one thing that's for sure is this is not something we can fix overnight, especially when the national average of vaping under the age of 18 is 32%. In Illinois, it's 39%. So it's an extremely high number for kids that shouldn't even have access to the product. So what we've been told is we need to look for a funding model between 5 to 10 years worth of funding. And so what we're going to look at is look at the cost it would be for you to be able to hire some additional staff, some SROs to be able to put on your campuses and get you that funding for the next 5 to 10 years. Then we also want to provide support to students. And one way we can support students is through being able to hire school counselors that have a background in addiction. Because now, as I said, this is a product that's extremely addictive, and we have kids that are dealing with addiction. And we want to be able to provide them that support. One of the superintendents who's an expert in our case told me that we take the student as a whole. We don't get to pick and choose what part of the student we're going to focus on when they're on our campus. So we need to deal with everything. And so if we have an addiction issue, we need to deal with it. And so that's going to be the importance of these counselors. And then the last part, which I believe is extremely important, is funding for education. Because as I said, what kids and parents know about this product and what the truth is, there's a big gap. And we need to be able to provide education to students so they can make decisions either to stop or to not do it in the near future. And also, we know that this is something that's being confronted in middle schools. So we even need to be able to provide education for children that are going to be entering middle school so that when they are confronted with this, they can make that educated decision to not do it.
Let me talk a little about when we talk about goals or objectives of litigation. You know, you always have to be ready to go to trial, but you also can settle a matter. And there are various vehicles that have been formulated over the years, have been put together to settle these mass litigations. I know that William and his firm has been involved in some mediations that have been used to resolve some of their cases. I was involved there was a vehicle called the Manville Disease Compensation Fund, which was put together to resolve the claims against the Johns Manville Corporation, which was undergoing reorganization. So the focus here is we'll be ready for trial. We have to be, but you know, to the extent that we can resolve these, because, and again, I asked William to speak to one more point, is there are legal products that Juul and the defendants market. Those can move forward, but it's the actions that they have taken that we believe that have been civil violations that we need to address.
So Mike, why don't you talk about how a school district can get involved, what steps they need to take, and then William, if you can talk about the timeline, what costs, if any, are involved, et cetera.
Sure. So again, this is affirmative litigation. So in order for a school district to participate in affirmative litigation, the board must take public action. And that public action takes the form of a resolution. And so what we initially recommend is that districts can contact us. We work with William and his team. We put together an initial communication for the superintendent and their team, so they can understand what the undertaking is. And we'll talk a little about what time is involved. You know, am I going to have more staff working on this than education? Hopefully not, and I think it's been streamlined to avoid that. Once you receive the information about the approach there, we'll prepare a resolution for the board to consider. We're happy to come and meet with the board. Because this is probable or imminent litigation, you're entitled to meet in closed session with the board to discuss the positives and any negatives of getting involved in such litigation. But once the board is ready to act, then you can act on that. There will be some agreements that will be put together between the attorneys, and then a formal complaint would be filed on behalf of your individual school district.
William, what's the timeline in terms of, you said the trial dates are set for spring of 2022. For the districts that would still be interested in getting involved, what should they be doing? And talk a little bit about that plaintiff fact sheet as well, the agreed upon discovery document.
Absolutely. So the timeline, as I said, we have a March 2022 trial, which that means either they're resolving it prior to that date. So that could be any time between, I would say, December to February of next year, or we're going to trial. And so what that means is that if a school district, charter school, private school wants to get involved, what we would recommend is that you join on prior to the end of November. That would give us enough time to get your case on file, work with your administration on the information we need, and then work on the discovery obligation. As it was discussed, this is not like normal litigation. So there's not going to be depositions, mass document production. We already have the districts that have been selected to do that work. All that's required from a school that joins on to this case is completing a questionnaire. It's about a 35-question questionnaire that should take your staff, I would say, around 2 hours to complete. That's the only obligation to be involved in this case. And we'll work with, you can work with my office, Mike, anyone to go, and if you have any questions to get it completed. Also, one point I want to make sure that's understood is that this is a case that's being handled on a contingency fee basis. So that means there's no cost for you to get involved in this case. We don't work on an hourly. What a contingency fee means is that if there is no financial recovery to you, then there is no cost. But if there is a recovery, then we're paid through a percentage of that recovery. Normally for plaintiff litigation, that would be 40%, but we've cut it to 25%. But again, the bottom line is that this can only bring in money to your schools. It cannot, not a penny of your general fund will ever be used in this case.
All right, so with that, here's, to the extent you don't have contact information for Mike or William or myself, feel free to reach out to us if you have any questions, if you would like to see the form of resolution Mike was referencing, or the attorney fee agreement, some informational documents we have that we've developed and we have from William, would be happy to provide that. So with that, I just want to thank everyone who has joined us this afternoon. Want to thank William and Mike as well for sharing their expertise. We'll be making this available on the firm website like we do with all our webinars. And with that, everyone have a great afternoon, and thank you so much.
Thanks, Harris.
Thank you.